my channel. My name is Meenakshi and I'm doing a video series on the Indian Contract Act. In today's video, we are going to discuss Section 20 of the Indian Contract Act 1872. Section 20 is relating to mistake. So there are basically three sections relating to mistake. Section 20, 21 and 22. In today's video, we are going to discuss what is Section 20 and what provisions are mentioned under this section. So the heading of Section 20 is Agreement Void when both the parties are under mistake as to the matter of fact. So what is this provision all about? It mainly tells when there are two or more parties to a contract. Take for example, there are two parties to a contract and both the parties are under some kind of a mistake. What mistake? Mistake with regard to fact. So, as we know that there are two types of mistakes. One is mistake of fact, one is mistake of law. So, Section 20 is applicable with regard to mistake of fact. That too when it's bilateral. As in, both the parties to the contract are under some kind of a mistake. So, this provision says that a contract where both the parties to it were under some kind of a mistake. What kind of mistake? With regard to facts of the matter. What kind of fact? That is important or essential to the contract. In that case, we will say that this particular contract between the two persons is void. So, what are the main elements of Section 20? Firstly, the mistake should be with regard to fact. Secondly, it should be bilateral, as in both the parties should be under mistake. Thirdly, the mistake should be with regard to some kind of fact which is essential with regard to the agreement. As in, it should not be some random fact that might not affect the agreement. It should be something that would affect our decision and would also affect the agreement. So these three conditions should be satisfied for Section 20 to be applicable. Now take for example, there are two persons. A, who is the owner of a horse, and B, he wants to buy a horse. So A made an agreement with B that I will be selling you my horse for 40,000 rupees. Both of them made the agreement, but later on it turns out that the horse is dead. Now this matter is very important, right? The horse should be alive for them to perform their contract. Obviously, B wanted to buy a horse which is alive. So this fact that the horse is no more alive is material. It's important for the matter. So in case there is an agreement between A and B with regard to buying of a horse and later on it turns out that the horse is dead, in that case we can apply Section 20 of Indian Contract Act. Then there is a mistake with regard to fact. What kind of fact? It is material or it's important for the agreement. And this mistake is bilateral. Both the parties are under that mistake. There is also one famous case relating to Section 20 of the Indian Contract Act. It is Tarsim Singh versus Sukhminder Singh. It's a case of 1998. In this case, Tasmir Singh was the owner of 48 canals of land and he made a contract with Sukhminder Singh for sale of those land. Now, Sukhminder Singh was thinking that this 48 canals of land, he is talking in terms of bighas. Now, bigha is like a larger unit of land as compared to canals. So, both the parties were thinking in terms of canal and bighas. That is, measurement was not proper, right? One person was thinking that for 48 bighas of land, I will be paying this much amount of rupees. And another person was thinking that for 48 canals of land, I am getting this much amount of rupees. So later on, it turned out that both the parties were not agreeing to the same thing. There was mistake with regard to measurement of the land and also with regard to payment. So in this case, Section 20 was applied and it was said that there is mistake. And this mistake is bilateral from both the parties. And this mistake is very important and material with regard to the contract because it is with regard to measurement and amount to be paid for purchase and sale of the land. So in this case, Section 20 was applied and the contract or agreement was declared as void. Now, this would not be applicable. Take, for example, I'm interested to buy a certain property from you for 40,000 rupees. After making the agreement, I went to the court and said that this contract should be declared as void because apart from me, C was also interested in buying this land. So in this case, the fact whether C was interested in buying the plot or not is not material. It should not affect our contract. Why? Because I was agreeing to buy the plot for 40,000 rupees and owner of this plot also agreed to sell it to me for 40,000 rupees. So the fact whether someone else was also interested or willing to buy it or not is not a material fact. So for section 20 to be applicable, we should fulfill three conditions. First is mistake of fact. Second is that fact should be material and the mistake should be bilateral mistake. It should take place from both the parties. It's not like I'm under some kind of a mistake, but it should be from both the parties. I hope section 20 is clear. In case you have any doubts with regard to any provisions of Indian Contract Act, you can let me know that in the comment section below. To check out more videos relating to Indian Contract Act, you can check out my playlist over here. And for more cases on Contracts Act, you can check out this playlist. Until we meet next time, bye-bye.